I must say, I thought we'd done away with standing. You'd all forgotten. As you can see, Mr. Page is with me. Miss Eliason Norris is not. She can't be here today, but she'll be watching the proceedings and obviously will have a transcript. And so will be just as au fait with what is going on as Mr. Page and I. I think we have a preliminary issue, if I can call it that, which I'll ask Mr. Beer to explain.
Thank you very much, sir. I was due to begin opening the issues that arise in phase 2 to 7 of the inquiry to you now, and to speak for the next day and a half about them. However, a pressing issue has arisen concerning Post Office Limited's disclosure to the inquiry, which I shall spend 15 minutes or so introducing now, and then give the floor to the legal representatives of those core participants who have indicated that they wish to speak about the issue. As you know, sir, in order for it to be able to carry out its work, the inquiry is reliant on those organisations who hold documents promptly to tell the inquiry that they hold such documents, and then to turn them over to the inquiry when requested to do so. The inquiry makes such requests by serving Rule 9 notices, that is, notices pursuant to Rule 9 of the Inquiry Rules 2006, to produce such material to the inquiry. The inquiry may serve such notices seeking particular named documents or broader classes of documents, perhaps those which concern an issue or which are within a certain date range or which are held at a certain location. When documents are handed over to the inquiry, there then begins a process which is set out in the inquiry's protocols to assess them for relevance, to ensure that any information in them which ought not to be disclosed is redacted before disclosure to core participants, and then the documents are disclosed to the core participants on an electronic disclosure management system. In order to be able to understand the document retention schemes and systems of relevant organisations and the processes which they have undertaken in response to the inquiry's Rule 9 requests, the inquiry may ask such an organisation to set these matters out in a comprehensive and complete manner in a witness statement, a so-called disclosure statement. This must be signed by a sufficiently senior and responsible individual within the organisation concerned, and it must be supported by a signed statement of truth. This allows the inquiry to assess the steps that that organisation has taken in response to its Rule 9 requests, in particular to see whether there are gaps or holes in the process. The inquiry has served 23 Rule 9 requests on Post Office Limited. It is right to say that the Post Office has disclosed to the inquiry a vast quantity of disclosure, almost half of all documents held by the inquiry. On the 8th of May 2022, Scotland on Sunday published an article by Nick Reed, Post Office's Chief Executive Officer. In that article, Mr. Reed stated that the Post Office had already provided over 3 million documents to the inquiry. That statement was incorrect. In a letter to the Post Office dated the 13th of May 2022, the inquiry noted that since its conversion back on the 1st of June 2021, the inquiry had in fact received some 36,639 documents. Mr. Reed later apologised for this error in a letter to the inquiry dated the 27th of May 2022, and that letter of apology was published on the inquiry's website. However, in the light of the discrepancy, and because of a number of tranches of disclosure had by then been completed by the Post Office, the inquiry sought an interim disclosure statement from the Post Office. On the 27th of May 2022, the Post Office provided a disclosure statement from Ben Fote, its General Counsel. That statement, which you've got, sir, as have the core participants, discusses hard copy documents at paragraphs 29 to 33. Just for your note, there's no need to turn it up now. That's tab 4, pages 16 to 17. at a relatively high level. It did not reveal the range of locations that we now know at which hard copy documents are in fact located, nor the scale of the disclosure exercise connected with hard copy documents that the Post Office needed to undertake. Those matters have been revealed more recently. To explain further, the Post Office has disclosed to the inquiry that it is undertaking a significant organisation and review of a large number of boxes of hard copy documents and files held at various Post Office locations throughout the United Kingdom. Over a series of letters, the inquiry tried to better understand the scope of the exercise so that we could consider its potential impact on our work and our timetables. We also tried to understand the overlap between recent correspondence and the previous interim disclosure statement. In short, the Post Office's ongoing hard copy review and related correspondence puts the inquiry in a very difficult position. We have limited information by which we can determine how much of the hard copy review is left to complete. We cannot know when we will be satisfied that the Post Office has completed its disclosure in response to all extant Rule 9 requests. By way of example, some of Post Office's recent hard copy document disclosures relate to Rule 9 requests that the inquiry issued as far back as October of last year. This makes it very difficult for the inquiry to know when the Post Office's disclosure will end, and therefore very difficult for the inquiry to work effectively and efficiently through the phases. We may be provided with highly relevant Post Office documents relevant to earlier phases after the hearings for those phases are complete. Those documents may be relevant to witnesses who have already given evidence and who may therefore need to be recalled. However, the inquiry has taken a number of steps as a result of recent events. Firstly, the inquiry has requested a second interim disclosure statement from the Post Office addressing their hard copy document review. In relation to the hard copy documents, this must address the following things: a chronology of the work that the Post Office has undertaken to locate, upload, review, and then disclose its hard copy documents since the 1st of June 2021, the setting up date of this statutory inquiry. The work that remains as at the date of the interim statement. It must set out all of Post Office's hard copy repositories. The Post Office has been asked to expressly state the name of each such location, the number of documents, or if the total number is unknown, to state as such and provide the number of boxes or files held at each repository, an explanation of the upload, review, or other disclosure-related tasks being undertaken at each repository. In other words, an explanation of the review progress made at each repository site. That statement is due by no later than 4 p.m. on the 18th of October 2022, after the oral opening statements have been completed. At this stage, the inquiry is minded to update representatives for court participants who have signed undertakings on or shortly after receipt of this second statement. The second step that the inquiry has taken, as you will have seen from the correspondence before you, is that as soon as the inquiry was alerted to the issue, it requested that the Post Office should review the hard copy documents for material that was relevant to phase 2 of the inquiry and prioritise the disclosure of that material. And for its part, the inquiry has sought to prioritise such material for onward disclosure to the core participants when it is received from the Post Office. It should be noted, however, that the inquiry has a large number of phase 2 documents with providers of documents at the moment, and we have asked for some ambitious turnaround times in order to give disclosure ahead of relevant witnesses giving evidence. Third, the inquiry took the decision that it was necessary, in the interest of openness and transparency, to disclose all of the material about which I've just spoken, the disclosure assurance statement, the correspondence that occurred since then, to all of the call participants. That happened on Thursday of last week. And of course, it was decided that it was necessary to allow core participants the opportunity to make any submissions on these important issues today. And so accordingly, you have allowed time for that to happen this morning. Fourthly, the inquiry assessed whether, in the light of the information now provided by the Post Office, some of which is not entirely clear, it was necessary to adjourn the starting date of phase 2 of the inquiry to allow time for all of the disclosure of relevant material by the Post Office to occur. The ongoing work by the Post Office in relation to a large number of hard copy files and boxes across various locations, the scope and significance of which the inquiry had not previously been made fully aware, means that it's likely that some further documents that are relevant to phase 2 of the inquiry will only be disclosed during the course of the inquiry. But what I would say is that the inquiry has always made clear that the phases of the inquiry are not hermetically sealed, and witnesses can be called and recalled at later stages. Further witness statements can be sought, and evidence can be read into the record at any time. This inquiry will not conclude until all core participants have met their disclosure obligations in full. In our view, there is not sufficient reason to interrupt the good progress that this inquiry is making. It may be that over the lifetime of the inquiry, core participants are provided with documents or with other information shortly before the hearings, but this will be necessary to achieve, or to help to achieve, one of the inquiry's core aims, that is to establish what went wrong as swiftly as possible so as to hold those responsible accountable, to learn lessons and prevent this tragedy from occurring again. Fifth, we suggest as your legal team that you devote some time within phase 2 of the inquiry to investigating the adequacy of the disclosure that the Post Office has given to the inquiry. It is, of course, something of a paradox, if not a matter which is dripping in irony, that I should begin this inquiry by a discussion over the adequacy of the Post Office's disclosure to the inquiry, when one of the very matters that the inquiry is investigating is the Post Office's past non-disclosure to the criminal and civil courts of this country. We appreciate that issues such as this may reinforce the beliefs of many as to the sincerity and accuracy of statements made by the Post Office as to its intention fully to cooperate with the inquiry. However, we suggest that this is not a basis on which to lose the momentum with which this inquiry has gained, in particular because it is likely to delay and frustrate the important progress that is being made properly and fairly to compensate all of the victims of this scandal. So that's all I say by way of introduction at the moment. You know, sir, who has suggested that they wish to make submissions now. I'll now give the floor to them, beginning, I think, with Mr. Steen.
Yeah, I think if it hasn't been made clear, I will hear the submissions in the order that you were each going to make your opening statements, if that makes sense. So I think that's Mr. Steen, then Mr. Maloney, then Mr. Henry. And I believe Ms. Gallifant wants to speak, and that's about it at the moment, though I will obviously ask any other core participants whether they wish to say anything. It should also be clear to you all that I have expressed a provisional view about the suggestion that I should adjourn the inquiry, and I'm not inclined to do it. But that's not to say that some flight of advocacy may not cause me to think hard and change my mind. But that is my provisional view, essentially for the reasons which Mr. Beer has outlined in summary. So I'd be grateful if those who are going to speak this morning focus their submissions on why there should be a postponement. They will have a further opportunity, if I do not postpone, to address issues of disclosure when they open their cases formally. So I would like to focus this morning on whether or not there should be an adjournment. All right?
Thank you,
so with those introductory remarks, Mr. Steen.
So good morning.
Morning.
Alongside Mr. Jacobs, I'm instructed by Mr. Enright and his team at Howe & Co Solicitors, and together we act for 153 core participants for this inquiry. So we're very grateful to you for allowing us the opportunity to address you on these disclosure issues, dripping with irony as they are. Our primary submission is that to go ahead now is allow the Post Office, yet again, to dictate the pace and content of disclosure. That's what they've been doing for 20 years, and that's what we suggest they're trying now and continue to do with this inquiry. Our clients believe they have earned the right to have a full investigation into this scandal, and we strongly suspect that you agree. We suggest that for a full investigation to take place, that instead of allowing the Post Office to disclose what it wants when it wants, that you should adjourn this inquiry with all of the inconvenience that that will cause to everybody that is connected with this matter, until at least the disclosure process for these first few modules are complete. The inquiry has been more than fair, extending the time for the Post Office to provide hard copy documents. And so the correspondence that we first saw last week on Thursday, I think it was, on the 6th of October at 6:30 in the evening, tells us that the inquiry extended the time for the Post Office to provide hard copy documents until the 29th of July 2022, and that's in the email dated the 25th of July 2022. The response to that from Herbert Smith Freehills is a reminder to the inquiry in its letter of the 5th of August that much of the material that the inquiry has requested in recent Rule 9 requests is historical, making the point, say, Herbert Smith Freehills, that in many instances the material is over 20 years old. Well, whilst that is absolutely true, perhaps we need to briefly remind ourselves that it is the Post Office that has been fighting this matter tooth and nail for very nearly a decade. It was in July of 2013 that Mr. Simon Clark, a solicitor from Cartwright King, who had prosecuted many of the cases, explained to the Post Office itself that the Fujitsu witness, Dr. Jenkins, the mainstay of many of its prosecutions, was not to be trusted. It might have been thought that that put the Post Office on some notice that they may need at that stage to gather the material that will be necessary to consider what has happened. And so you're also being told that at Chesterfield and other sites, in the letter from Herbert Smith Freehills, dated the 5th of August, that the Post Office believes it can decide to what extent disclosure can or will take place. So I'm quote from the letter of Herbert Smith Freehills, dated the 5th of August of this year. Notwithstanding that there is a risk that Chesterfield and other sites hold further material that is relevant to the inquiry's terms of reference, Poll considers that to complete a comprehensive hard copy review of all of the material would neither be necessary or proportionate, bearing in mind the volume of material that would need time reviewed on site and the additional time and expenses that would be incurred. Well, understandably, on behalf of the inquiry, Ms. Smith asks in her letter, dated the 26th of August 2022, on what basis have you determined that further hard copy reviews are not necessary, in addition to not being proportionate? Making the clear point that it is not for them to make such decisions. Now, we've mentioned the fact that the Post Office perhaps should have been on notice, considering the background of the matter regarding the Clark advices. But not only that, the second site reviews, the judgment number 3 by Mr. Justice Fraser in March of 2019, judgment number 6 in December of 2019. This inquiry was established in non-statutory form on the 29th of September 2020. In April of 2021, the Court of Appeal overturned convictions. and this inquiry was then converted into the statutory inquiry on the 1st of June 2021. There could be no doubt at all that the Post Office has been on notice throughout all of that time that they need to gather all material that would be relevant to the purposes of all of those proceedings and make sure that they were ready to deal with whatever investigation was required. In the judgment of Lord Justice Holroyd at the Court of Appeal, the failures of investigation and disclosure were, in our judgment, so egregious as to make the prosecution of any of the Horizon cases an affront to the conscience of the court. Repeating, really, the point that we have both made, myself and my learned friend, Mr. Beer, that disclosure really has been at the heart of all of these issues. Now, so the terms of reference and scope to this inquiry state the government wants to be fully assured that through the inquiry there is a public summary of the failings associated with Post Office Limited Horizon's IT system, and says it will consider all other relevant evidence, listen to those that have been affected, understand what went wrong, and assess whether lessons have been learned and whether concrete changes have taken place or underway at Post Office. If you were sitting, sir, as a High Court judge in this situation, dealing with matters in litigation, our respectful submission is that there would be no hesitation. This would be a matter dealt with by way of an adjournment, an explanation that has already been asked for, and a query as to how the cost should be borne. Well, in principle, we say the same should apply here.
Well, that's what I find difficult, because I have all the flexibility of an inquiry, not a sort of 4-week time slot or whatever, which will mess up every other list and so forth and so on. So I know that analogy has been made, but I do think that in an inquiry I have such a great deal of flexibility compared with a normal court case that we ought to forget about court procedures, Mr. Seen.
The analogy holds good, we say, because in order to proceed at this stage, without the relevant documents having been disclosed, on which we can make judgments as to how to put forward questions, how to deal with openings, how to in fact consider the shape in terms of submission to the inquiry, the shape of the inquiry itself. It goes to the questions of what has happened so far from Mr. Scipione, the IT expert that's been brought in, what material should go to him and his team that has considered it over, I think, many months in the summer. So, sir, the difficulty is that the inquiry may be in fact saying, well, we can deal with it as you go along. This is a rolling inquiry. We can catch up. We can go back to matters, recall witnesses. Essentially, our clients say that is jumping to the tune that is being played by the Post Office. Now, you've asked for flights of advocacy to consider the possibility of changing what is so far your mind. Well, I'm not sure I'm up to that. What I can, though, is do this. I can say this. The Post Office has denied sub-postmasters and mistresses any choice in their lives. They demanded of them investment. They demanded of them application in their work. They demanded of them that they comply with a contract that effectively said that they must pay up no matter whose fault it is. They then, of those individuals, prosecuted them before the civil courts and the criminal courts, and many went to prison. Their lives has been dogged by lack of choice from the Post Office. It is a significant matter that we ask you to take into account, sir, that their choice is to adjourn. That doesn't mean that this matter should necessarily be left today and we abandon all of this equipment that's been so kindly and time-consumingly set up. What it does mean is that you could go ahead with what we can so far by way of openings, but then adjourn before we get to evidence. So before I sit down, let me just read you 3 examples of the many emails that we have had concerning this particular question from our clients. From Malcolm Simpson. I'm emailing you by return to fully support your actions following this development on the eve of the inquiry. As you have stated in your letter to Sir Wynne, none of us is surprised by the Post Office's actions, just angry and disappointed that they have been playing the same old games with absolutely no respect for anyone. Just protect the brand, despite their reputation being continually shredded because of their consistently behaving in the worst possible way for many years, abject arrogance. Please keep fighting tooth and nail to bring these people to task. Rita Threlfall. I fully support and trust any action you feel necessary regarding the inquiry. I'm mortified to hear of Post Office behaviour. Have we not been proven innocent? It is a living nightmare grieving for our past lives and some redress. Will we ever be treated fairly? John Stevens. The Post Office and their legal team's behaviour comes as no surprise. The events of the last 20 years have clearly shown they have no intention to do anything but hide their actions from bottom to top up behind smoke and mirrors. Justice Fraser could not have been clearer on his opinion of their actions, and we are yet again dealing with their duplicitous behaviour. Our clients want this inquiry to proceed. They want this inquiry to proceed with all due celerity. They want this matter to find who's responsible, who is accountable. They want it done properly. They want it done with this inquiry in charge of disclosure rather than the Post Office in charge of disclosure. This is the only opportunity to have this particular matter looked at in its entirety. Our client's point is, let's start it right. So those are our submissions.
Thank you, Mr. Steen, for powerful and succinct submissions. Mr. Maloney.
Thank you, sir. So this joint application is pursued with considerable regret. Until Thursday evening, our understanding was that the inquiry was satisfied with response to each of the Rule 9 requests. And we don't repeat the sorry history of the Post Office's disclosure failings over the years. They are extensive, as outlined by my colleague, Mr. Steen, King's Counsel. And in that context, the fact that disclosure issues have arisen again is surprising only in the sense that it would have been hoped that Post Office would have gotten its act together by now, but no. And to illustrate that, sir, might we go to just one document that the Rule 9 process has generated? And I think this can go on the screen. Yes, I'm grateful to Mr. Beer, King's Counsel. It's the minutes of the Audit, Risk and Compliance Committee of Post Office Limited on the 22nd of September 2020. And it's the reference for those who would seek to find it later is POL 000-21462. And these are the minutes of the Audit, Risk and Compliance Committee from the 22nd of September 2020. If we could please go forward to page 5. And to the bottom of that page, we see there at 4.8, this is the commencement of this topic within the minutes, which is GLO, Freedom of Information, FOI, request GDPR and data protection. This team is extremely busy dealing with requests related to historic shortfall scheme and related linked FOI requests. He advised of 39 FOI inquiries considered vexatious, which will be reviewed accordingly. But over the page, more importantly, from September 2020, of serious concern and committee discussion was the discovery of 31,000 boxes previously unknown to the wider organisation, which are being reviewed. The committee questioned whether management had a handle on data management controls, such as archiving, and remarked on the lack of accountability within POL. NR, and that's Nick Reed, the Group Chief Executive Officer, remarked that this was an unacceptable incident and that he did not expect this to be brought to the committee's attention by compliance. A paper on data controls is expected at GE for discussion, and the committee recommended a data amnesty be organised for all post officers be considered. And then if we just move forward to the action points on page 13, we see at 4.8 that the recommendation is that a paper on data controls is expected at GE for discussion following the identification of 31,000 boxes of data, and over the page 4.8 continued at page 14 that the committee recommended a data amnesty be organised for all post officers be considered. And so that was in the context, and that was at a time when disclosure was at its height in respect of the criminal appeals. And it provides context, we say, sir, for the Post Office's latest citation of its administrative arrangements in response to the inquiry's requests. We are years on from that unacceptable incident, just over 2 years on from that unacceptable incident, and the Post Office has long known that this inquiry would need its full and careful cooperation. We say that adjournment is necessary in the interest of preserving the integrity and effectiveness of this inquiry, sir. And to focus now on the main question you ask, why shouldn't you stick to your provisional decision rather than simply complaining about what Post Office has done in the past and is doing now? To proceed to opening, but much more importantly, oral evidence in these circumstances creates a real risk of prejudice both to court participants and to witnesses as well, sir, because material may emerge which undermines the points that I might, for example, wish to develop in questioning. Material may emerge which would alter the whole structure of questioning by court participants. And coming back to witnesses is never ideal. And indeed, paradoxically, sir, in an attempt, and I don't say this is your motivation for your provisional decision, sir, but in an attempt to save time now, it may extend the time that you have to sit to hear evidence. Moreover, perhaps in keeping with the emails that Mr. Steen has just read out, far from allaying rumour and suspicion, we say that with deep regret that proceeding to evidence would, rightly or wrongly, potentially generate considerable speculation. So in the context of the long period of time preparing for this inquiry and the period of time that this inquiry will receive evidence, a short adjournment would, we say, be proportionate. Our clients in the impact hearings have told you, sir, how important this inquiry is for them, and they've put their faith in the inquiry and in your team. And, sir, they're impatient to know why the Post Office acted as it did. And it's because the inquiry is so important to them and to the public interest that our clients would ask that it be done right, as they might see it, and be seen to be done right, and that an adjournment at this time of a short duration would be proportionate. And that's all we wish to say, sir.
Thank you very much, Mr. Maloney. Mr. Henry.
Thank you, sir. The effect of this announcement has had a psychological shock upon the core participants. I, together with Ms. Page and Mr. Schwartz of Hodge, Jones and Allen represent and have the honour to represent, because it, as it were, echoes appalling instances of injustice that occurred in their own lives. Take the case, for example, of Miss Felstead, who was told that she could be part of the mediation process and then was told that she could not. And it transported her back almost 20 years to when, as a teenager, she was sent to a young offenders institution. And I suppose the reason why I stand on my feet now and I support my learned friends is for this reason. It's to treat these people at last with dignity, a dignitarian approach, not a pragmatic approach. And I do not, sir, submit that you are motivated by saving time. You will take as much time as you need. What you're concerned about is not losing momentum. But what is momentum if we set the wrong tone at the outset, if the angle of trajectory is distorted by non-disclosure, then you may not reach your ultimate objective, the target that you, I submit, long for as well, because it is evident from everything you have said and done that you want this inquiry to be effective, and that you have been, notwithstanding your many years in the practice of the law and dispensing justice, shocked by what you have already heard. I'm afraid I can't use the analogy of a puppy, because, of course, the post office is a far more sinister and, I regret to submit, malevolent animal. But you have to train an unruly participant. And the only way you can train it is by actually not acceding to its continuing contempt for the process. It has demonstrated time and time again that it cannot be relied upon or trusted to comply with court orders. Once more, it has demonstrated that it is unwilling or unable to meet deadlines which have been set, and it is utterly incorrigible. And so really, I suppose my submission is Pavlovian, that yes, we do lose to some extent momentum, but we will regroup, and then we will attack this subject with even greater momentum and confidence, knowing that a marker has not simply been laid down, but imposed upon an institution which seems incapable of acting fairly towards those it has maimed and marred. As you know, sir, in the case of the core participants we represent, the Post Office exercised almost total power over them. It treated them contemptuously. It subverted the rule of law to suit its own agenda. It twisted, distorted, and overrode vital processes in both civil and criminal courts, depriving the core participants of vital rights, which meant that the law could not protect them, which meant that the system of justice that we fondly believed would intervene, in fact, was enlisted in support of the Post Office's vendetta, because it did flatten people who sought to challenge the narrative. Now, it is therefore now time, we respectfully submit, that control is imposed upon them, that they are treated with firm and obdurate, well, not obdurate, but with firm and rigorously imposed resolution that this must not be allowed to take place, because otherwise, I respectfully submit, as the history of the Horizon litigation in the High Court has shown, and also the criminal litigation in the Court of Appeal, that the Post Office will fail to comply. So, out of dignity for those we represent and for all the court participants represented by my learned friends, and also out of, I suppose, a Pavlovian imperative, you have to impose control now, sir, upon them. This is a seismic moment, and I respectfully submit that your laudable desire for momentum has to be sacrificed in order to ensure that the Post Office do not continue to act in its arrogant and imperious way. Those are my submissions.
Thank you, Mr. Henry. Is there any other core participant present who wishes to support the application for an adjournment other than the Post Office? I don't know what they're going to do. Let's see if there's anyone else who wants to say anything for the moment. Right. Well, then I think, Ms. Gallifant, you wanted to make submissions.
Thank you, sir. We're grateful for the opportunity to respond to the concerns raised by representatives of the Postmaster Corps participants. The allegation made in the application that we received on Monday is that Post Office is continuing in what is alleged to be a pattern of late and partial disclosure of relevant documents, as well as continuing to obfuscate attempts by others to obtain those documents. We emphatically deny that Post Office has deliberately sought to make late and partial disclosure of relevant documents. To put Post Office's disclosure exercise in relation to hard copy documents into context, it's important to note that to date, first, as Mr. Beer indicated, there have been 23 separate Rule 9 requests issued to Post Office. In response, approximately 95,000 documents have been produced by Post Office to the inquiry. That's across more than 60 separate productions. The production of those documents has taken place from a review pool of approximately 50 million documents, and then a review of approximately 213,000 documents deemed to be relevant from the initial search. The documents that have been disclosed were collated from an assessment of 173 Post Office databases, 201 Post Office SharePoint sites, 8 external digital repositories, and 248 physical locations. It is understood that there is some suggestion by Mr. Steyn that Post Office's disclosure has resulted already in delay to the start of this phase. For the avoidance of any doubt, our understanding, sir, from your public announcements in relation to the starting date of this phase, is that it was because of the volume of disclosure that the inquiry had received and would wish to consider. That, of course, is not only by Post Office but by other core participants. Certainly not a failure to make disclosure. What we say the correspondence between my instructing solicitors and the inquiry team demonstrates is that Post Office did draw the inquiry's attention to some of the challenges faced in relation to hard copy documents in the interim disclosure statement dated the 27th of May 2022. And at the beginning of August, Post Office updated and proactively updated the inquiry as to the progress that it was making in relation to hard copy documents. In mid-August, it indicated it would shortly be in a position to produce the first tranche of additional relevant hard copy documents, noting that fewer than 100 further responsive documents have been identified relating to the various Rule 9 requests that had been received at that time. There were 16 at that point. By the 6th of September, the number of additional hard copy documents which were provisionally identified as relevant to Phase 2 was around 625. After review, documents which were identified as relevant to Phase 2 as well as Phase 4 were provided to the inquiry on the 13th of September 2022. The disclosure of those documents was made as soon as it reasonably could have been, having regard to the nature of the exercise being undertaken, and there was certainly no intention to delay their disclosure. There was equally no intention to obfuscate attempts by the inquiry to obtain those documents. On the contrary, in correspondence, Post Office set out in detail the steps that it was taking in order to review potentially relevant documents so that it could make disclosure of any such documents to the inquiry. Now, we understand from Mr. Beer's submission this morning that the inquiry team felt that further detail could and should have been provided, but that is something that was and can continue to be addressed both in correspondence and, of course, in the disclosure statement, the second interim disclosure statement, which will be supplied to the inquiry on or before next Tuesday. So we do emphatically refute any suggestion that we have intended to obfuscate attempts by you, sir, and your team to obtain these documents. There are two ongoing areas in which the exercise of identifying and reviewing potentially responsive documents has not yet been completed. And these appear in the correspondence, and let me summarise them. The first concerns unindexed or inadequately indexed boxes and files. Now, this issue was first identified in the interim disclosure statement from May of this year, which identified the lack of indexing or the inadequacy of certain indexing at the time understood to be about 5,000 documents at its offshore storage provider's site. It said that those had recently been indexed as part of a programme undertaken by Post Office, and the indices which had been produced were in the process of arranging to be reviewed. It subsequently transpired that in total there were about 5,000 unindexed boxes and files, but also about another 4,000 boxes where the indexing was inadequate. And Post Office, via my instructing solicitors, updated the inquiry about that on the 5th of August of this year. The new indices, including those where the indexing was inadequate, were provided to Post Office's solicitors on a rolling weekly basis in order for them to review each new index and identify if the boxes or files contained any documents responsive to the Rule 9 requests it had received by that date. Having reviewed the new indices produced during August, Post Office's solicitors identified an initial tranche of documents which it considered might relate to Rule 9s responsive to Phase 2 of the inquiry, and these, as I've indicated, were provided to the inquiry in early September. A tranche of 278 items was also identified in August, which they considered may relate to Rule 9s responsive to Phase 3 of the inquiry. Now, these documents are in the process of being scanned and in some cases reviewed, and Post Office expects to be in a position to provide any relevant documents identified well in advance of the start of Phase 3 of the inquiry. In addition, after reviewing a further tranche of indices received throughout the month of September, as I've indicated, they were provided on a rolling basis as the process continued. During the week commencing the 26th of September of this year, a further 111 boxes and 19 files of hard copy documents were identified from those new indices as being potentially relevant to Rules 9s that had previously been received. Of those boxes and files, as at today's date, 16 items, either boxes or files, have been identified as being potentially relevant to Phase 2, 89 potentially relevant to Phase 3, and 25 potentially relevant to Phase 4. There have since been 2 supplemental indices received from the indexation exercises completed by Post Office. These have been reviewed for relevance to current Rule 9 requests. None of those documents have been identified as relevant to Phase 2. For completeness, sir, I note that the indexing exercise being undertaken by Post Office is nearing completion. We understand there may be additional indices, which is anticipated will be provided to those instructing me once finalised, and they will be reviewed for potential relevance in the same way as previous indices. Can I go back then to the additional 111 boxes and 19 files? It had initially been intended for these relatively recently identified items to be scanned before being reviewed. Post Office has now arranged for a team of 5 of its solicitors from Herbert Smith Freehills and a senior employee of Post Office to travel to the off-site storage provider's site in Winchester tomorrow and Thursday if necessary to conduct the review in person. The team will prioritise the review of any documents potentially responsive to Rule 9 requests in relation to Phase 2, and if any are identified, Post Office will obviously provide copies of such documents to the inquiry at the earliest possible opportunity. The second area in which the disclosure exercise has not yet been completed, and again, the background is set out in the correspondence, concerns files which were uploaded to the online document hosting platform Omnidocs. At the time of Herbert Smith Freehill's letter of the 6th of September, when these were referred to, more than 28,000 files had been uploaded, of which 17,862 had been identified using a basic search as containing the word Horizon. It has subsequently proved harder than anticipated to review those files due to the limited search functionality of the particular platform onto which they had been uploaded. And it was Post Office's initial view, as communicated to the inquiry on the 29th of September, that it would be unlikely to be possible to review the files in a timely or proportionate manner. After further consideration, Post Office determined last week that it should review a sample of those documents to reach a more informed view of the extent to which these files might contain potentially responsive documents. Its solicitors will therefore now be undertaking a review of 500 documents from the Omnidocs set, which they expect to be able to complete by next week. On the basis of the outcome of that review, Post Office will be in a position to update the inquiry as to whether it considers that the public interest in obtaining the information outweighs the cost and time, bearing in mind how important the information is likely to be. That, of course, reflects the test, which is established by Section 21(4)(b) of the Inquiries Act. In relation to a claim by a person, it's not reasonable in all the circumstances to require them to comply with a Section 21 notice to produce documents in their custody or control. Of course, no such notices have been issued in relation to any of the Rule 9s to date, but in our submission it's appropriate to have regard to the same threshold test when considering whether it's reasonable for Post Office to respond to a Rule 9. Of course, we make no submissions at this time prior to the sample as to whether it would or wouldn't be. We fully recognise that if the sample exercise indicates that the public interest would outweigh cost and time, it would have to move with all possible expedition to complete an appropriate review of the full set of files to minimise the impact on the oral hearings in Phase 2. All of the issues that I've identified in terms of recent developments and updates from the end of the correspondence trail will of course be covered in the second interim disclosure statement due next Tuesday. In these circumstances, our position is first that there is no basis for adjourning the hearings this week, and the application to do so should be declined. Post Office would wish to reiterate it remains committed to responding fully to all Rule 9 requests, unless there are particular circumstances where it considers it's not reasonable to do so, which it will then invite the inquiry to consider and offer a view on. It will continue to flag up to the inquiry and correspondence any difficulties or potential delays with disclosure exercises, not limited to Phase 2, but otherwise, and seek to find practical and workable ways through. It very much apologises for the fact that it's necessary for this issue to take up time at the outset of the hearing, but we recognise, of course, the concerns and the rationale for them raised by my learned friends. We fully recognise that the inquiry will wish to review the situation once it's in receipt of the second interim disclosure statement, and we note Mr. Beer's suggestion that some time during the forthcoming phase can be taken on the issue. Obviously, we don't object to this course of action. In the circumstances, we respectfully agree there is no basis upon which to lose the momentum provided by the start of this phase, in particular not to adjourn today, and we say matters thereafter are matters that can properly and fairly be considered during the course of Phase 2, and of course the inquiry will make such directions or such decisions as it considers appropriate in due course. Thank you.
Thank you. Before I ask Mr. Beer if he wishes to say anything, are there any co-participants present who wish to support the view that I should not adjourn or postpone the hearings? Right, Mr. Beer.
So two things. Firstly, it probably wouldn't profit you for me to go through the file of correspondence that you've got to pick out of it areas of contrast between the information that has now emerged and what the inquiry was told earlier in the piece from May onwards. I can do that if that's necessary, but I think it probably wouldn't be.
Well, I'm going to ask you the direct question, Mr. Beer. In the light of what the various parties have said, do you wish to modify, in effect, the advice you were giving me in your opening statement?
No, thank you, sir.
Right.
The second thing I wanted to say is that we will, of course, give close scrutiny to the information that Ms. Gallifant has just provided, which to an extent goes beyond that which we already knew.
Sure. Right. It's 11:25, and I will take a little time to reflect upon what is being said to me, so I shall come back at 22 or thereabouts and tell you how I propose to proceed. Thank you.
So may I raise just one matter?
Certainly.
My instructing solicitor have prepared a schedule, a short schedule, you'll be pleased to hear, of client comments. This represents only a sample of what we've been told. Obviously, it's a matter for the inquiry to look at and can be disclosed to my own friends.
Well, I'm very happy to receive it, as you'd expect, Mr. Steen, but I can well understand that many of your clients are happy with what you've told me. Happy is the wrong word, are content with what you've told me, and that they're fairly represented by the 3 specimens you gave. But if you think that I would be further assisted by it, of course I will receive it.
So we certainly think you should read it.
Fine, then I will.
Thank you.
So, is that in hard form or what? Because I take it you'd like me to read it before I announce my decision.
That's right, at the moment. We need to switch on and off. It's been emailed to your solicitor, sir.
Fine, and no doubt they will pass it on very quickly. So it'll be 22 or thereabouts, depending upon the speed of transfer. Thank you. Mr. Steen, just to clarify what I've received, I was given a hard copy document which has representations from 17 of your clients, if my adding up is accurate, beginning with Ms. Palmer and ending with Ms. Hazelton. And then my solicitor to the inquiry had a separate document with 9 names on it, sent by email, most of which are different from these, but there are 2 or 3 overlaps. So I'm proceeding on the basis that I have read approximately 25 representations. Is that a fair summary of the position?
So yes, I think what's happened is that because this has been quite a fast response, us having been put on notice last Thursday, you've had the full list, but the smaller schedule is in fact the ones that we decided should go to the inquiry.
Right.
The full list was one, in fact, I believe, that was sent to the team here, so that I could get a hard copy.
Fine.
But I don't think it does causes any problems at all in you seeing all of it.
And unless you say otherwise, I think it's only right, since you asked me to take this into account, that both documents go to the core participants in due course.
Yes, I've briefly taken instructions. We agree.
Fine. Thank you. Well, let me say at once that in reaching my decision, I have taken account of the representations which I have read from a number of core participants, and as I've said, the full document begins with representations from Ms. Palmer and ends with representations from Ms. Hazelton. The representations support an application which has been made to me to adjourn or postpone the start of phase 2 of the inquiry. I say start because it became clear during the course of the oral submissions that at least some of those supporting a postponement would be content for opening statements to be made, but do not accept that I should begin to hear evidence. It is obviously regrettable that disclosure of documents potentially relevant to phase 2 is not yet complete. That seems to me to be clear from the correspondence which everyone has seen and from the oral submissions which I have heard today. That was not a surprise to me, in the sense that my team has been reviewing this issue over the last number of many weeks, and my legal team has been considering over that time whether or not it was appropriate to start these proceedings on this date. And as Mr. Beer explained in his opening remarks, notwithstanding the fact that disclosure in relation to Phase 2 was not complete, he and the legal team had reached the conclusion that nonetheless it was appropriate and reasonable to begin today. I issued a provisional view to the same effect after I had received the written representations made on behalf of the core participants who sought an adjournment. I say now that despite the powerful advocacy which has been displayed before me this morning, I am still of that provisional view. A public inquiry is a flexible creature. I think those of you who have appeared before me regularly know that I am a flexible creature. I do not think it appropriate to be hamstrung by straitjackets or anything of the like. The issue for me, as I see it, is whether or not I can proceed fairly, reasonably, and appropriately, notwithstanding that disclosure is not yet complete. And I believe that with appropriate management and assistance from everyone, which includes my legal team and every other legal team, I can proceed. The plain fact is that when one is investigating events which occurred 20 years ago, as we are in this phase, it is of no surprise that sometimes there are glitches in relation to disclosure. I appreciate that there are many people listening to my words who might wonder whether or not I am going to control disclosure in the way that I have been invited to do so. Let me assure them that I do intend to control disclosure. No one should be under any illusions. The obligation to disclose relevant documents is ongoing and will persist throughout this inquiry until the very day when I hand over my report to the Minister. I wish to make it clear that if I reach a conclusion at any time that there is either accidental or even worse, deliberate non-disclosure of relevant documents, I will use all the extensive powers at my disposal to obtain the documents which have not been disclosed. Everyone should understand, and I know that the lawyers do understand, that proper disclosure is crucial to the success of this inquiry. Those are general remarks. I have considered whether we have reached a point where we need to pause because there is a danger that the non-disclosure which has occurred to date will interfere with my aims for this inquiry. For the reasons essentially articulated by Mr. Beer, I have reached the conclusion that that stage has not been reached. I am satisfied that I can manage disclosure. If it is necessary, I will set aside days in this phase or any other phase to consider disclosure as a discrete topic. If it is necessary, I will attribute blame to any party where that is justified in relation to non-disclosure. I will not deflect from being critical if it is necessary to do so. So this is a crucial part of this inquiry, and I wanted to lay down those guidelines, as I will call them, in the hope that I never need to get to directions or even more draconian use of powers. I also have to bear in mind the effect that an adjournment or postponement would have at this stage of the inquiry. With respect to those who suggested that it might be a short adjournment, I beg to differ. The reality of an adjournment would be a reasonably lengthy period of time while I satisfied myself that every single relevant document had been disclosed. That would have very significant impact upon those timetables which have already been drawn up with considerable care by my team. And it would have a very significant impact, therefore, going forward on every other phase of this inquiry. While expediency about timetables is not an overriding consideration, it is an important consideration for all those sub-postmasters, and I use the term generically as we always have, because they do need answers as soon as is reasonably practicable, as I have been at pains to stress in virtually every public statement I've ever made. So balancing all the relevant considerations, and despite the powerful advocacy of those promoting a postponement, I've decided we should carry on. But let me make one thing clear. The disclosure duty is a continuing one, and I will supervise it with as much vigor as I can. Throughout my years as a lawyer and judge, I've been in too many cases where disclosure difficulties have started to become, let's say, very difficult to reconcile with proper objectives. I will not allow that to occur in this inquiry. Thank you. Mr. Beer.
So thank you. If I may, I'll open the remaining phases of the inquiry. The long fought...
Actually, Mr. Beer,
Yes.
before you start, and to save my aged hand, there used to be in this inquiry almost a more or less contemporaneous transcript of what you were saying, which saved me from having to make extensive notes, even though in an old-fashioned way I used to try. Is that facility still available?
So it is, and it should be on the screen in front of you, I think. I'll just pause.
Well, even pressing the button, which is about as much technology as I'm good for, doesn't seem to bring that up.
So I'll pass no comment on that last remark, other than to recognise it. I wonder whether somebody from RTS could help. I understand that you've got an evidence screen,
right.
Not a transcript.
So
Sorry, you've got a transcript screen, not an evidence screen. That will be rectified.
So at least before lunch, I have to resort to the old-fashioned note-taking, Mr. Beer.
Yes.
All right.
Well, it's not completely, because obviously a transcript will be available, in due course.
Sure. Yeah. Fine.
As I was saying, the long-fought group litigation in Bates and others against the Post Office came to an end in December 2019. On the 26th of February 2020, the then Prime Minister, Boris Johnson, committed to getting, quote, to the bottom of the matter, end quote. And by the 10th of June that year, the government had confirmed that there would be what was first called an independent review to be led by an independent chair. The Post Office Horizon IT inquiry was first established in a non-statutory form on the 29th of September 2020. On the 5th of October 2020, the inquiry published an open letter aimed at seeking information from the public and started discussions with individuals and organisations and the process of gathering of evidence. a number of developments occurred in the months that followed. Most significantly, on the 23rd of April 2021, the Court of Appeal Criminal Division handed down its judgment in the case of Josephine Hamilton and others against the Post Office, which quashed the convictions of 39 sub-postmasters, where the reliability of Horizon data had been essential to their prosecution. As you did, sir, I should say at this point, I will refer to sub-postmasters throughout this opening. That is to be taken to include sub-postmistresses, managers, and assistants. That judgment, as I will set out in due course, included new information which had not previously been disclosed, including what has become known as, quote, the Clark advice, namely advice to the Post Office from a barrister, Simon Clark, which highlighted serious failings with expert evidence that had been relied upon by the Post Office in prosecutions, and further failures in respect of the duty to record and to retain information. On the 19th of May 2021, it was announced that, having digested the judgment of the Court of Appeal and returned to the judgments of Mr. Justice Fraser, that you had requested the conversion of the inquiry into a statutory inquiry and had suggested amendments to the terms of reference. It was considered that the powers available to a statutory inquiry, including the power to compel evidence and hear evidence on oath, were necessary to support a proper assessment of the relevant facts. The inquiry was therefore formally converted from the 1st of June 2021. Since that date, the inquiry has published a range of protocols, including a protocol for providing oral evidence at hearings, a protocol on witness statements, a protocol on redaction, anonymity and restriction orders, amongst others. 2 assessors have been appointed, as you know, David Page of Celerius Consulting, who sits next to you, as an assessor in relation to digital product management, IT strategy for large and complex technical projects, usability and associated business processes, in essence our technical assessor, and Erica Eliason Norris of Beyond Governance as a governance assessor. As you have said, sir, she joins today remotely. On the 17th of November 2021, a completed list of issues was published following a process of consultation with core participants and other interested persons, and in the light of written and oral representations. The next day, the inquiry sought permission to investigate matters relating to the devolved administrations, following concerns that had been raised during the consultation on the list of issues as to whether and to what extent there had existed divergences in the policies and practices adopted within the 4 countries of the United Kingdom when taking action against sub-postmasters. Permission was granted by the then Minister for Small Business, Consumers and Markets, Paul Scully MP, on the 30th of March 2022. Meanwhile, we began the human impact hearings on 14th of February this year. Those hearings focused on the human impact of the adoption, implementation, operation and continued use of the Horizon system, and the human impact of the approach taken by the Post Office to sub-postmasters when the system showed shortfalls, including their suspension, the termination of their contracts, the closure of their branches, proceedings for the recovery of so-called shortfalls, bankruptcy proceedings, criminal investigations, and ultimately criminal proceedings. The reason that we commenced the hearings of the inquiry by listening to the accounts of those who were and continue to be affected by the flaws in Horizon and the flaws in the Post Office's approach to it is that they must be front and centre of this inquiry. As I set out in my opening to that phase, although the underlying subject matter of the inquiry is information technology, this inquiry is not and will not become a dry technical investigation into an IT project gone wrong. That's because it's an inquiry that's actually about people whose mental and physical health has been impacted, about people whose marriages and partnerships have deteriorated and failed, about people who thought about taking their own lives, and in some cases, who took their own lives. Between February and May of this year, we heard from some of those affected. The inquiry travelled to Cardiff, to Leeds, to Glasgow and to Belfast, and heard powerful accounts from victims and in some cases family members, including from those whose loved ones did not live long enough to see their convictions overturned. In terms of disclosure, the inquiry has sent 91 requests for information under Rule 9 of the Inquiry Rules 2006, requested witness statements from 309 witnesses, and disclosed to core participants a total of 10,237 documents. This work will, of course, continue over the coming months. Along with Julian Blake, Catriona Hodge, Sam Stevens and Ruth Kennedy, I act as counsel to the inquiry. As you may know, but others may not, our role is to assist you in the conduct of these investigations. We're entirely independent and impartial and do not represent the interests of any of the core participants in the inquiry, or indeed of any other person. Also appearing today, and I'll only introduce them once in the course of the inquiry, and in no particular order, are the following representatives of core participants. Tim Maloney, King's Counsel, and Angela Patrick, instructed by Hudgell Solicitors for 64 sub-postmasters. Sam Steen, King's Counsel, and Chris Jacobs, instructed by Howe & Co. for 153 sub-postmasters. Edward Henry, King's Counsel, and Flora Page, instructed by Hodge, Jones and Allen for 5 further sub-postmasters. Kate Gallifant, King's Counsel, instructed by Herbert Smith Freehills for the Post Office Limited. Richard Whittam, King's Counsel, and Tim James Matthews, instructed by Morriston and Forrester for Fujitsu. Paul Mertens, instructed by Evershed Sutherland for UK Government Investments, or UKGI. Nick Chapman, instructed by the Government Legal Department for the Department for Business, Energy and Industrial Strategy, or BEIS. Samantha Leake, King's Counsel, instructed by Mishcon de Rea for Paula Venables. Phase 2. I now turn to address the matters which will be examined during the Phase 2 hearings, which commence with evidence next week. As you know, sir, Phase 2 of the inquiry is concerned with the first iteration of Horizon, known as Legacy Horizon. During Phase 2, the inquiry will examine how this first iteration of the Horizon IT system came into being, and will be focused upon decision-making in relation to the following 4 overriding themes. Firstly, the procurement of the Horizon IT system. Secondly, its design and development. Thirdly, the Treasury review and cancellation of the Benefits Payment Card, or BPC. And fourthly, the acceptance and rollout of Horizon. The significant modifications which were later made to Horizon will be examined in further depth during Phase 3 of the inquiry. You will also hear during Phase 3 from witnesses who were involved in the early decision-making relating to Horizon and who continue to have direct involvement in the operation and management of the system after it was rolled out to post office branches nationwide. Their evidence will, of course, be of relevance to the issues that you will be determining as part of Phase 2 as well. Can I now then turn to address each of the 4 of the Phase 2 themes that I mentioned in turn? Procurement of the Horizon IT system. The plan to bring modern technology to the entire post office network was first conceived in the early 1990s. At that stage, the post office consisted of 3 principal businesses: post office counters, Royal Mail, and Parcel Force. Post office counters was the business responsible for running the national network of post offices, which at that time comprised of approximately 19,700 branches. Over 95% of those branches were run as private businesses by agents of the post office, known as sub-postmasters. For many years, post office counters have worked in close partnerships with the benefits agency, facilitating the payment of state benefits over the counter at post office branches nationwide. In the early 1990s, the method of paying state benefits via the post office was paper-based and reliant upon the use of order books or green gyro checks. It was expensive for the benefits agency to administer benefit payments in this way, and the system was considered to be very vulnerable to fraud. An alternative method of paying state benefits directly in relation to a recipient's bank account had already been established by the benefits agency. This method was known as, with capital letters, Automated Credit Transfer, ACT, and was less expensive than paying benefits via the post office. Transferring recipients to payments via ACT would have reduced the administrative costs borne by the sponsoring department of the benefits agency, which at that time was known as the Department of Social Security, the DSS. However, the income associated with the payment of state benefits accounted for more than 1/3 of post office counters' business and was considered at the time to be essential to the survival of the post office network. For this and other reasons, the option of making payment via ACT compulsory was not pursued by the DSS. Instead, post office counters and the DSS embarked upon a joint venture to automate the payment of state benefits over the post office counter via the use of an electronic payment card. The benefits agency acted as the sponsor of the automation project on behalf of both the DSS and the Northern Irish Department of Health and Social Care, as well as other agencies. From the perspective of the benefits agency, the principal objectives of the project were: 1, to eliminate encashment fraud; 2, to reduce their administrative costs substantially; and 3, to improve their financial accounting and management of information. Although one of the principal objectives of post office counters was to retain the business of the benefits agency, the automation project had the broader objective of modernising the post office network. At the time, post office counters operated a paper-based accounting system across its network of, as I've said, nearly 20,000 branches, which was costly to reconcile and was considered to act as a barrier to attracting new business. Automating the sale of post office products and post office counters' other client transactions was intended to increase efficiency, improve business competitiveness, and enable post office counters to attract new clients. The process of procuring a new IT system to automate the payment of benefits at post office branches was managed by a joint programme team with significant input from external lawyers and consultants. The joint programme team was staffed with representatives drawn from the two project sponsors, Post Office Counters and the Benefits Agency. It was led by a programme director, Andrew Stott, who had previously worked as a senior official within the DSS. Mr. Stott reported to a programme steering committee which comprised of the Chief Executive and Finance Director of the Benefits Agency, the Managing Director and Commercial/Resources Director of Post Office Counters, as well as senior officials drawn from Her Majesty's Treasury, as it was then known, the Department of Trade and Industry, the DSS, the Northern Irish Office, the Private Finance Executive. It was the preference of the government of the day that funding for the project should be sought from the private sector, and the new IT system therefore be procured under the Private Finance Initiative. The procurement process was launched on the 30th of August 1994 by the publication of a notice in the official journal of the European Communities. For the transcript, but not needing to be displayed, the reference to that notice is WIT N 0337-0102. One of the businesses which expressed an interest in the project was International Computers Limited, ICL, a British manufacturer of computer hardware and software and a provider of computer services, which was partially owned by Fujitsu Limited, a Japanese information and communication technology company. ICL established a subsidiary company known as Pathway in order to bring together a consortium of businesses which could jointly bid for the project. The other members of the consortium included De La Rue and Gyrobank. The process of shortlisting the potential service providers which had responded to the OJEC notice was undertaken in the autumn of 1994 and resulted in the selection of 5 companies: BT Syntegra, Cardlink, EDS, IBM, and Pathway. On the 13th of April 1995, the project sponsors issued to the 5 shortlisted companies a statement of service requirements, known as an SSR, which, amongst other things, described the functional requirements which each of the sponsors expected the project to deliver. That SSR can be found but needn't be displayed at poll 3028135. The SSR summarised the principal tasks of the service provider as follows. 1, to provide, operate, support and manage an IT infrastructure which would enable the automation of services at post offices. 2, to automate the end-to-end benefit payment system. 3, to integrate with the computer systems of post office counters and the benefits agency, as well as those of their agents and clients. 4, to migrate the project sponsors' existing automated systems. And 5th, to integrate post office counters, the benefits agency, and third-party software applications. Each of the 5 shortlisted suppliers' responses to the SSR were assessed by an evaluation team against 3 sets of criteria addressing the characteristics, the viability, and commercial aspects of the supplier's proposals. That exercise can be found but needn't be displayed at poll 3028282. At the conclusion of their assessment, the evaluation team produced a report for the members of the Project Evaluation Board to assist them in selecting a final shortlist to move to the more detailed demonstrator and negotiation phase of the process. That can be found but needn't be displayed at poll 3028149. The evaluation board comprised representatives of post office counters, the benefits agency, the Social Security Agency of Northern Ireland. It was chaired by Robert People, P-E-A-P-L-E, Executive Director of Post Office Counters. In its report to the evaluation board, the evaluation team identified 2 principal areas of risk in Pathway's proposed solution. The first area of risk was technical and associated with Pathway's proposal to adopt a distributed solution which would enable transactions to be processed at the post office counter without requiring continuous connection to a central processing system. The technical risks which were seen to be inherent in such a solution were twofold. Firstly, the greater complexity of the system software required to manage such a system, and secondly, the greater complexity of administering benefit payments at any post office branch other than the one specifically nominated by the recipient. The second area of risk identified by the evaluation team was commercial and related to Pathway's apparent refusal to accept any risks for financial losses arising from fraudulent copying or counterfeiting of the benefit payment card. However, the evaluation team did not consider that this commercial risk ought to preclude Pathway from proceeding to the demonstrator and negotiation phase of the procurement exercise, where the method of cardholder verification could be examined more fully. Ultimately, in July 1995, Pathway was shortlisted alongside Cardlink and IBM to continue to the next phase of the exercise. The demonstrator and negotiation phase of the procurement exercise was intended to serve three principal objectives. Firstly, to clarify and define more precisely the requirement of the two sponsors. Secondly, to obtain a clearer understanding of the supplier's proposed solutions to them. And thirdly, to prepare draft contracts defining the rights and obligations of the three contracting parties. These activities were underpinned by a capital letters service provider risk register, which was regularly reviewed and updated as new risks in the supplier's proposed solutions were identified and steps taken to mitigate or to eliminate those risks. That can be found but needn't be displayed at DWP 6036. The risks associated with each of the supplier's proposed solutions were ranked according to their severity, with the most critical risks being classified as Category A. That can be seen but need not be displayed at Fujitsu, that's FUJ 3078056. Each of the shortlisted suppliers was notified of the risks identified in their solutions and afforded an opportunity to respond to the concerns raised by the programme team, either in writing or during their weekly demonstrator meetings with representatives of post office counters and the benefits agency. You can see some examples of those. We needn't display them at FUJ 3078002 or WITN 059700140. You'll be hearing evidence from Jeremy Folks, Folkes, a software developer employed by post office counters who participated in this demonstrator workstream. He will say that Pathway appeared defensive in its meetings with the project sponsors and appeared keen to avoid scrutiny. We'll see that in his witness statement at WITN 05970100 at paragraph 43. You will wish to consider, Chair, whether these observations mirror trends noted later in the development of the project. In order to proceed to the final stages of the procurement process, known as the capital letters invitation to tender, each of the service providers were required to revise and develop their solutions to ensure that they met or exceeded, firstly, the minimum service requirements acceptable to the project sponsors, secondly, the minimum requirement for partnership with post office counters and the development of new business opportunities, thirdly, sufficient transfer of risk for an acceptable risk profile, in particular relating to fraud, and lastly, an acceptable funding method and finance structure. One can see those criteria at poll 3028297. One of the principal methods by which the joint programme team determined whether or not these hurdles had been met was by reference to the service provider risk register, which I've mentioned already. The stated intention of the project sponsors was to exclude from the invitation to tender any shortlisted suppliers who had Category A risks or, quote, an unacceptable profile of other risks, end quote, outstanding at the conclusion of the demonstrator and negotiation phases of the procurement. We can see that that is so, i.e. as a stated intention to exclude suppliers who had any Category A risks from poll 3028297. An assessment of Pathway's proposed solution in November 1995 identified 4 outstanding Category A risks, as well as 20 Category B risks that were described as, quote, significant. The greatest area of concern to the joint programme team related to Pathway's proposed reliance on a software platform known as Riposte, which had been developed by a small software company called Isha, based in the United States. The project sponsors had serious concerns about the scalability of Riposte and perceived that ICL did not have a sufficiently deep understanding of the software to answer their questions. It was noted that Pathway had the highest number of Category A and B risks of the three shortlisted suppliers, and that further work needed to be done to clear the risks if Pathway was to be permitted to proceed to the invitation to tender. One can see that at poll 30-28148. The demonstrator and negotiation phase came to an end in February 1996. An analysis of the service provider risk register carried out on about the 19th of February 1996 established that CardLink and IBM had no outstanding Category A risks and accordingly should not be excluded from the invitation to tender. By contrast, Pathway had two outstanding Category A risks and was therefore considered not to qualify for the final stage of the procurement process. I think we could look at that document usefully, please, at poll 30-28150. You'll see the date in the top right-hand corner, 19th of February 1996. And if we go to page 3 of the document, thank you very much. One can see a table here. This is of the Pathway risks. You'll see that under the column risk severity A, there were two outstanding. I should say this is not our highlighting. The highlighting is as it appeared in the document that we have been given. And you will read at paragraph 2.3.2, Pathway has two A risks. In accordance with the procurement policy concerning A risks, the programme should not invite Pathway to tender. You'll see a scribbled note on the right-hand side, now changed and cleared, 26, and that's a 2, I think, told at evaluation board. We'll come to that in a moment. And so the two outstanding Category A risks recorded against Pathway related, on the one hand, to Pathway's continuing refusal to accept any risk for financial losses arising from fraudulent copying or counterfeiting of the benefit payment card, and on the other, to Pathway's proposed financial and funding arrangements, which were considered to represent an unacceptable risk to the project sponsors. We can take that document down now. In addition to the two outstanding Category A risks, Pathway had 9 outstanding Category B risks, reflecting a higher aggregate risk profile than either of its other two competitors. The significant Category B risks associated with Pathway's proposed solution related to a variety of technical and contractual issues arising from Pathway's reliance on the Riposte software produced by Isha and the adequacy of its proposals to ensure payment security and to eliminate fraud. As I've said, in the light of Pathway's outstanding Category A risks, it was recommended that the consortium be not invited to tender. The ultimate decision as to whether any of the shortlisted suppliers ought to be excluded from the invitation to tender rested with the evaluation board. Prior to the meeting of the board on the 26th of February 1996, you remember that was the date in that handwritten comment, further efforts were made by Pathway to mitigate its 2 outstanding Category A risks, and contractual negotiations with all shortlisted suppliers continue to take place. We can see that, but it need not be displayed, at poll 30282990. Although Pathway was deemed by the time of the meeting on the 26th of February to have cleared the hurdle of satisfying the minimum service requirements acceptable to the project sponsored, there remained concerns on the part of the Joint Programme Team about Pathway's management and its technical capability, which raised fears about their ability to deliver the contracted services on time and to quality. We can see a reference to that, a record of that, in poll 3028291. At a meeting of the Evaluation Board on the 26th of February 1996, which was chaired by Robert People, the board expressed, quote, severe reservations about the number and significant risks against the Pathway proposal, and, quote, questioned whether the cumulative effect would not lead to potentially late delivery and or operational problems, and as such was cause for Pathway to be excluded from the invitation to tender. We can see that, and I'd ask for it to be displayed, at poll 30282888. This is a note of the meeting on the 26th of February of the Evaluation Board. You can see that in the 5th line in the heading, the chair of it is Robert People, Bob People. And then if we go forwards, please, to page 3. And look at paragraphs 2.7 and 2.8. With respect to the certificate for Pathway, the Evaluation Board expressed severe reservations, thank you, about the number of significant risks against the Pathway proposal. It questioned whether the cumulative effect would not lead to potentially late delivery and or operational problems, and as such was cause for Pathway to be excluded from the invitation to tender. Particular concerns were expressed about the card technology with shortcomings in the associated management of fraud, and about the dependence on eShare as a small company subcontracted to Pathway. And then at 2.8, Tony Johnson explained that these issues had indeed been given much consideration by the demonstrator team. It had concluded that the Pathway solution was not fundamentally flawed, and that from a strictly technical viewpoint, the hurdle had been cleared. In its overall decision, the Evaluation Board might wish to take into account the cumulative effect of any contractual issues with those from the requirements area. Having been informed by the programme team that Pathway's 2 outstanding category risks were capable of being cleared following further contractual negotiations, the Evaluation Board concluded that the other outstanding risks registered against Pathway's proposed solution did not warrant their exclusion from the invitation to tender. And therefore, on the 29th of February 1996, the invitation to tender was issued to all 3 of the shortlisted suppliers. The final stage of the procurement process was known, again capitals, as the evaluation and selection phase. Its purpose was to make a final assessment of the relative merits of each of the shortlisted suppliers' bids and ultimately to lead to the award of a contract, provided that a suitable provider could be identified. The evaluation process comprised of 3 principal work streams. First, a review of the extent to which the supplier's bids complied with the requirements of the invitation to tender. This was known as contract assurance. Secondly, an evaluation of the financial impact of awarding the contract to each of the 3 shortlisted suppliers, known as, quote, the financial evaluation. And lastly, thirdly, an assessment of the characteristics and viability of the supplier's proposed solutions, known as the value factor assessment. In addition to these 3 aspects of the evaluation process, assessments were made both of the supplier's partnership capabilities and also of the extent to which their bids made provision for risk transfer that was sufficient to comply with the requirements of the private finance initiative. Paul Rich, who was then the Partnership Development Director of Post Office Counters and a member of the Evaluation Board, will be giving evidence to the inquiry in which he will say that the level of risk transfer mandated by the private finance initiative was, quote, a critically important criterion, as neither of the project sponsors had the resources to fund the design, manufacture, installation and operation of the new system, and wished to transfer those risks, together with the risk of fraudulent encashments, over to the supplier. We will see that at WITN 040-30100, paragraph 33. The value factor assessment, capital letters, represented the key area of qualitative analysis and was initially undertaken after the invitation to tender, but prior to receipt of the supplier's bids. It drew heavily on the knowledge and understanding of the supplier's proposed technical solutions, which the project team had gleaned during the demonstration and negotiation phase. We can see a table at poll 30-28294. If we go forwards, please, to the 3rd page of that document. In tabular form, we can see that out of the 3 shortlisted suppliers, CardLink, which occupies the 2nd and 3rd columns, obtained the highest overall score, and that although Pathway's performance, which are the last 2 columns, was broadly aligned with its competitors in devising a solution which was acceptable to the project sponsors and their agents, it scored substantially less against a number of important matrices, including credibility of delivery, management capability, reliability and support, and stability and coherence. And so overall, in qualitative terms, Pathway was assessed by the programme to be the weakest of the 3 candidates. That can be taken down, please. On the 21st of March 1996, each of the 3 shortlisted suppliers submitted their responses to the invitation to tender. Upon analysis of their bids, it transpired that each had been priced at a level which was higher than the indicative figures which had been produced at the time of their original proposal, and risked rendering the sponsors' respective business cases unviable. In the light of this risk, an invitation to retender was issued to all 3 candidates on the 16th of April 1996, and their revised bids were provided to the programme on the 22nd of April 1996. The process of financial evaluation was carried out by the joint project team upon receipt of the supplier's revised bids. Its purpose was to establish the quantitative differences between the bids in purely financial terms. CardLink emerged from the evaluation as substantially the most expensive of the 3 suppliers, with IBM marginally outperforming Pathway on the total costs of its offer. We will see that Pathway came in as the cheapest at poll 28153. In tandem with this financial evaluation, a review of each supplier's retender was conducted by something called contract assurance. Of each of the three suppliers, Pathway was found to have assumed the greatest level of risk for fraud associated with card counterfeiting, hacking, and customer validation. According to the contract assurance team, the limits which the other two candidates had placed on the scope of their contractual liability for fraud rendered their bids, quote, difficult, if not impossible to accept. It was the conclusion of the contract assurance team that CardLink should not be awarded the contract, quote, at any price. Of the remaining candidates, it concluded that Pathway ought to be preferred to IBM, unless IBM's bid offered, quote, a considerable price advantage. We will see that at poll 28152. The process of selecting the successful candidate commenced on the 26th of April 1996 at a meeting attended by 6 representatives from the evaluation team. You will be hearing from David Miller, a deputy director of the programme in 1996 and a member of the evaluation team who attended that meeting. Mr. Miller states he was unaware at any time of any issues with ICL's ability to assist with the automation process. That's in his statement at WITN 03470100, paragraph 24. You, Chair, will wish to examine that what might be a surprising assertion in the light of the strong concerns that had been earlier articulated by the programme about Pathway's overall management capability, its failure to demonstrate leadership within the consortium, and its ability to deliver services to time and to quality. At the meeting on the 26th of April 1996, the evaluation team concluded that CardLink ought to be eliminated from the competition. Of the 2 remaining candidates, IBM's performance in the qualitative value factor assessment remained substantially better than Pathway's, despite Pathway's scores improving as a result of the retender. Moreover, these 2 suppliers were virtually equal on price. However, IBM's contractual stance, in particular on fraud risk transfer, was deemed to place it at a material disadvantage to Pathway, and its bid was therefore regarded as non-compliant with the Private Finance Initiative. If we can turn up poll 3031153 and turn to page 22, please. Maybe back a page, please. Yes. If we look, please, at 9.7, the record of the approach and conclusions of the evaluation team was that the group recognised that an award to Pathway would imply a need for a proactive management stance. That's a phrase that we will see quite a lot in phase 2 of the inquiry, would imply a need for a proactive management stance by sponsors, notwithstanding the improvement noted by the contract stream since the restructuring immediately prior to the invitation to tender issue. It would also require sponsor staff to work closely with Pathway on fraud prevention measures, although given the changes on fraud risk made by the other 2 bidders in their retenders, most of this work was likely to be required whichever supplier was chosen. And therefore, we can see at 9.9, the group therefore unanimously concluded that it should be recommended to the evaluation board that any contract award should be made to Pathway.
And can I just check, Mr. Beer, is the highlighting of these passages on the original document or subsequently?
All original. We've not marked up any document at all. we have in our personal notes, obviously,
Yeah,
but that's
sure.
not what is being
Yeah.
displayed.
Right.
This is the state in which we received them. That can be taken down, thank you. Shortly thereafter, the Evaluation Board met under the chairmanship of Robert People to discuss the findings of the evaluation team and to reach a decision on the selection of a supplier. For substantially the same reasons given by the evaluation team, the board reached the unanimous conclusion that if the project sponsors were to decide to award a contract, the award should be made to Pathway. The board reiterated that the selection of Pathway would, quote, require a proactive management stance by sponsors, thereby acknowledging the identified weaknesses in areas such as the credibility of delivery by Pathway and weaknesses in Pathway's management capability. We can see that, but needn't turn it up, at poll 3028450. Robert People will be giving evidence to the inquiry in the coming weeks, and he will state that the approach adopted by the sponsors to the procurement was, quote, extremely thorough, and that the evidence made available to him does not indicate that there were any flaws in the evaluation process. He says that in his statement at WITN 040200100. You, Chair, may wish nonetheless to explore why it was that Pathway's solution, whose implementation was known to involve a higher level of technical risk than its competitors, was chosen by the Evaluation Board. Endorsement of the Board's recommendation was subsequently sought from the Programme Steering Committee, which met on the 1st of May 1996 under the chairman of Peter Matheson, Chief Executive of the Benefits Agency. The committee unanimously endorsed the conclusion of the Evaluation Board that Pathway should be selected as the chosen supplier of the services. Although the committee observed that Pathway's technical solution involved, quote, an added element of technical risk, end quote, the committee expressed confidence that Pathway's performance could, quote, be managed effectively, end quote, by the joint project management arrangements which have been agreed between post office counters and the Benefits Agency. We'll see a record of that recommendation at DWP 6029. Within the Post Office, the proposal to select Pathway as the chosen provider was scrutinised by both the Major Projects Expenditure Committee, known as MAPEC, and the Post Office Board. MAPEC, whose members comprised Richard Close, Jeremy Cope, and John Roberts, Chief Executive of the Post Office Group, met on the 30th of April 1996 and noted that Pathway's technical solution was, quote, the least preferred, end quote, of the three, and, quote, presented a higher risk to delivering the programme, end quote, by reason of its complex design, which was unproven on a large-scale deployment and involved bespoke code, which would have to be modified. The committee observed both short-term and long-term risks in selecting Pathway included late delivery, the pressure to accept incomplete functionality, premature rollout, which would prove to be unreliable, and lastly, a fragile software system. However, the committee concluded that such risks were, quote, manageable and could be effectively mitigated by stronger technical assurance, rigorous user and system testing, and appropriate contingency planning by the supplier. In the expectation that appropriate conditions would be imposed to give effect to these measures, the committee endorsed the selection of Pathway. We can see a record of that. It needn't be turned up at poll 3028451. You, Chair, may wish to consider whether the committee's expectations in relation to strengthening technical assurance of the system were realistic in view of the inherent constraints which arose from the transfer of risk to the supplier for the system's design and development. At a meeting of the Post Office Board on the 7th of May 1996, authority was granted to the Post Office counter to enter into contracts with the benefits agency and Pathway, subject to the resolution of a funding issue affecting the Social Security Agency Northern Ireland. Having approved the selection of Pathway and having obtained authority from the Treasury for funding of the contract, Peter Lilly, the then Secretary of State for Social Security, made a public announcement on the 15th of May 1996, confirming the selection of Pathway as the chosen contractor to finance, supply and operate the new automated system for post office transactions and benefit payments. Can we look at that, please, at poll 3089859. The Secretary of State's announcement says, the Secretary of State for Social Security has today announced that the joint programme to bring technology to post offices and benefit payments, Benefits Agency and Post Office Counters Limited, has chosen Pathway as the contractor to finance, supply and operate the new automated system. This is a milestone of major significance to our organisations. Mr. Lilly also announced the design of the benefit payment card, which is integral to the new method of payment. The card will simply be known as the payment card. Pathway is a consortium led by ICL plc, including such companies as Delarue and Gyrobank. All consortium members are specialists in their own fields. They complement each other and ourselves by offering expertise in areas such as plastic card production and distribution, and we shall now be starting a period of intense activity to further develop and test the new system. We expect the first benefit payment cards to be used in Great Britain by people in receipt of child benefit starting from the autumn. That's autumn 1996. Although there has been some rescheduling of the timetable, we still expect to have all post offices automated and all benefit payments, including those of the War Pensions Agency, being paid by card by 1999. For the Benefits Agency, changing the way benefits are paid at post offices will reduce benefit payment fraud because the computer system will confirm the amount to be paid to the customer and enhance the service to customers by providing a more secure and convenient alternative to Girotex and order books. It will also support the Benefit Agency's change programme, which aims to deliver our service more effectively and efficiently. For Post Office Counters Limited, automation means greater choice, convenience and personal service to customers and clients. Bring it into line with the best retail practice. Automation will protect the nationwide network of post offices by securing a contract with the Benefits Agency for the next 8 years. The introduction of this new technology will also help extend Post Office Counter Limited product range and help it to retain and grow core and new business. We've come a long way since 1993 when Post Office Counters Limited and the Benefits Agency joined forces to introduce a new way of paying benefits at post offices. We still have a lot of work to do, but by continuing to work together, we will remain on target to achieve the first payments by card at the first post offices later this year. Can I turn then to the second topic in phase 2, design and development. Having been selected as the preferred candidate to bring modern technology to post office branches and benefits payments, Pathway entered into 3 related agreements. The first was with post office counters and the Department of Social Security acting jointly and was known as, quote, the Authorities Agreement. We can see that, needn't turn it up, at poll 28175. The second agreement between Pathway was with post office counters alone. We can see that at poll 28181. And the third agreement was with solely with the DSS. We can see that at poll 28178. Each of the three agreements specified the project sponsor's functional requirements at a high level, leaving responsibility for the detailed design and development of the hardware and software necessary to deliver those services to Pathway itself. There were essentially two key aspects to the automation project which Pathway undertook to deliver. Firstly, Pathway was obliged to devise a service which would enable the automation of benefit payments at post office counters. The names given to the core element of this service were the Benefit Payment System, BPS, or Benefit Encashment System, BES, which were used interchangeably. The purpose of BPS or BES was to enable those who ran post office branches to make payments to customers of the benefits agency upon presentation of their benefits payment card. The system was supported by additional back-end systems developed exclusively for the benefits agency, which included a card management system and a payment authorization system. In addition to the BPS, Pathway developed an additional optional service at the request of the benefits agency, which was known as the Order Book Control Service, OBCS. This provided a temporary mechanism designed to prevent fraudulent encashment of cancelled or stopped order books pending their complete replacement by the benefits payment card. The second major aspect of the project related to the automation of other services and transactions at post office branches. This aspect of the solution was devised exclusively for post office counters and comprised of, firstly, an electronic point of sale service, an EPOS, EPOSS, and secondly, an automated payment service, an APS. EPOS was intended to process the purchase of post office products and services by customers of post office branches, whilst the APS was designed to enable the incremental payment of bills by the customers of post offices' counter clients, such as utilities companies, and the recharging of cards and keys used to access such facilities. Part of the considerable complexity inherent in the project arose from the need to integrate these various services with parallel computing systems being developed internally by the benefits agency and post office counters. One of the systems which Pathway was required to integrate was the Customer Accounting and Payment System, CAPS, which was being developed by the benefits agency in order to create a uniform method of recording and disseminating information relating to customer payments. In order to ensure the accuracy of payments being made via the benefit card, it was necessary for data stored on CAPS to be fed to the systems which Pathway was developing to support the BPS. The principal systems in the post office domain with which Pathway was required to integrate were firstly the reference data system, which recorded details of, for example, post office branches, products and prices. Secondly, the host automated payment system, HAPS, which managed post office counters' existing automated systems. And thirdly, transaction information processing, TIP, which was required to extract data from Pathway systems in order to reconcile it with post office counters' own accounting and management information systems. Shortly after the contract was awarded, ICL purchased the shares at which De La Rue and Gyrobank owned in Pathway and changed the company's name to ICL Pathway Limited. And I will now, from now on, refer to the relevant company as ICL Pathway. Responsibility for overseeing the development, delivery, and integration of this complex web of integrated systems and services rested with something called the Programme Delivery Authority, PDA, which was staffed by representatives from both post office counters and the benefits agency. The PDA was governed by a board whose membership was drawn from the senior management of ICL Pathway, from post office counters, from the benefits agency, and from Social Security, the Social Security Agency of Northern Ireland. A programme steering committee provided direction and guidance to the programme. Its membership comprised Stuart Sweetman, the Managing Director of Post Office Counters, Peter Matheson, who, as I said, was the Chief Executive of the Benefits Agency, Alec Wiley, spelt with a C, the Chief Executive of the Social Security Agency Northern Ireland, and Keith Todd, the Chief Executive of ICL. The first key milestone of the programme was the development and implementation of a pilot scheme known as Initial Go Live, IGL. The primary purpose of IGL was to demonstrate the successful functioning of the benefits payment card by the target date of the 23rd of September 1996, scarcely 4 months after the award of the contract. By reason of the very compressed timetable for delivery of the benefit payment system and its associated back-end services, only very limited functionality was available. And therefore, the service was initially rolled out to a single post office in Stroud, Gloucestershire, and only permitted the payment of child benefit to 14 people. We can see that at FUJ 30588278. You'll be hearing evidence from John Meager, who acted as the as the Horizon Product Assurance Manager. He describes this initial go live as, quote, a PR exercise, which, quote, distracted from the primary objective and wasted valuable time and resources. The cross-reference to that is WITN 0415010. You, sir, may consider that delivering the initial go-live by the September deadline was a Pyrrhic victory in the light of the chronic delays which subsequently beset the programme, and to which I will turn, if it pleases you, after lunch.
Impeccable timing. Thank you. 2 o'clock, everyone? Thanks very much.
Thank you, sir.